So why is it that we've chosen this topic today? And you've got a host of speakers from industry and from the competition bar who've come from Singapore and Zurich on this. It's because every competition regulator in the world today is seized of the issue. What is next for big tech? What do they want to do in terms of regulating digital economy players? And what is India doing in light of all of this? Are we following global best practices, or are we going to repeat the same mistakes that are being made everywhere else? There is a lot to be said on this topic, and given that we have only 45 minutes, we're going to start right away. I'm going to start with you, Adiraj. Are there actually benefits to digital economy platforms, or is it all bad?
Thank you so much, Nisha. Let me jump straight into some things which may not be readily obvious. I will not waste everyone's time with the general benefits of digital platforms, which we all know about, which is the ease of access, convenience, so on and so forth. Just give you an industry-specific example so that you have an idea of the depth which digital platforms in India have reached so far, of the milestones which are still to be reached, and how the benefits have still not accrued. We might have just scratched the surface, but there's a long way to go yet. So Make My Trip obviously works in the hospitality sector, and let me just focus on hotels for now because that is the simplest way to give this example. For the longest time, and even today, most of the hotels in India are booked offline. And what that means is that when offline, and 70 to 80% of hotels in India are small and medium businesses, they are mom and pop or family operated businesses. So what that typically means is that these hotels have no way of going out and making their inventory available to the world. And the only avenue, so if you talk about a small hotel in a, say, a city like Udaipur or maybe a small hotel in Manali, the only way they have of reaching a global audience, or even reaching the audiences in Delhi and Bombay, is through an impartial digital platform which is going to make their voice heard. And that impartial digital platform, in a way, is an alternative to, say, turning into a franchise hotel or turning into a global chain hotel or something of that nature. These digital platforms that you have today, be it Make My Trip, be it Swiggy, be it even Amazon or Flipkart for that matter, these digital platforms provide the ability for small and medium businesses, including in tier 2 and smaller towns in this country, to effectively compete, get their voices out there and be part of the digital revolution. And if you look at the broader metrics, and if you look at the fact that most of the market is not only still under-penetrated, but also the fact that most of the business which comes in today and most of the economics which keeps digital markets afloat comes in only from Delhi, Bombay and Bangalore, it really puts into the perspective the fact that there is a long way to go and a lot of digitization ahead to really help tier 2, tier 3 cities in this country come forward, and SMBs in particular in India come forward, make use of digital platforms and really take India into the next century. PM Modi's goal of making India a 5 trillion economy, 10 trillion economy will really depend to a large degree on how much penetration digital markets can get and how much we can help SMBs grow and come to the fore.
Abhinav, who's also from Swiggy and has stepped in kindly for Avantika today. Abhinav, what benefits do you see from digital economy platforms, apart from the fact that Swiggy has helped keep a lot of us alive in COVID times?
Sure. So I'll start by just explaining what Swiggy essentially does, right? We are basically in the business of providing convenience. So, and in the context of our food delivery business, for example, the way we provide this convenience is by providing a tech platform where you can search or you can discover or you can list a restaurant partner or any restaurant, and the restaurant can essentially interact with customers and delivery executives, right? So we are providing a platform of convenience that helps various third parties kind of interact and do business in a very efficient manner. So on the one hand, we have created a level playing field for restaurant partners who can kind of list themselves and have access to the online food business generally, and also have access to online users. And on the other hand, we are providing customers with unparalleled choices for specific products that they may desire. Um, so for us, that's, we look at it as that, right? The biggest sort of USP for us is we are providing convenience. In addition to that, like all digital platforms, obviously we are also creating a lot of jobs. There are a lot of gig workers associated with the platform who are dependent upon orders placed through Swiggy. We are helping the restaurant industry in general scale down costs as volumes go up. These are some of the broad benefits that I'd like to highlight.
We've heard from both the industry players on the benefits. Let's see why the competition regulators are up in arms and what are the perceived potential harms, because none of these have been proven yet to be real harms. Phil, let's start with you on this one.
Truly being in the spotlight here, so speaking as if I were the regulator. So me as a regulator, I've always been too late. You guys have always grown faster than I could possibly be in controlling what we perceive as damaging. And what do we mean by damaging? You've grown too big, too fast. You're controlling data, big data. You've been scaling up to the extent that you can play with network effects on both sides, both your suppliers and your customers are becoming dependent on you. You're locking them in. You're integrating vertically. So basically, you've become big giants. And with the tools that we have from a competition law perspective, we did not manage fast enough to use those tools and apply them. And that is why we have all these big cases. They take years, so on and so forth. We need to regulate you before you get there, in order for you not to get to the point where we have difficulties to control and where we want to protect our customers, consumers. That's where we are coming from.
Kala?
Okay, I'm going to stay true to myself. I'm not a regulator, lawyer in private practice, and nevertheless picking up on the points that Phil has made, in relation to, actually, before I get to Phil, if I may, I'm just going to go to you first. One of the key points you said is we bring convenience to consumers. True, convenience comes to consumers, and yet through that convenience, you end up knowing what my choices are, what my preferences are. So I hear of many of my colleagues who get into they call for a Grab car. I forget, I don't know what it's called in India, but in Singapore it's Grab, or in a lot of Southeast Asia it's Grab now. So you call, and typically you say you call for the car at 9 p.m., 10 p.m. because as a lawyer we work very late in the office, right? Yeah, right. So because Grab also has access to restaurants and so on, you order your car. Once you get into the car, the app will then sort of point you to, maybe you need dinner. What about stopping by or ordering this from this place and picking it up before you go back? Or maybe why not order so that when you get home, it's delivered in time as well. I see a lot of people nodding. On the one hand, it's brilliant. That's convenience. I love it if someone's taking some thinking out of me, right? And those of us who cook every day, you have to think about what to cook. It's crazy. And yet that, I think, is the perceived harm that regulators have. They say that the choice is being taken away. They say that something's being pushed onto us. And it is true. So the likes of Swiggy and so on, they are doing something which is not necessarily the best. And yet, as I counted, I said that actually there are advantages because it takes away some of my thinking, makes it a lot easier for me. And why shouldn't it be that way, provided that I'm not being forced? yeah, there's a subliminal sort of thinking that I'm going to order from you. But if I'm independent minded enough, I'm going to say, no, I'm not going to order from Grab. I'm going to go to Food Panda, Delivery Hero, using Southeast Asia's examples again for food order. And let me give you another example before I start showing you the other side. Netflix. There's been a lot of studies done with the likes of Netflix, with the likes of any online search platform that you have, where you watch a certain movie and then it comes up with, because you watched this, maybe you're interested in this whole range of things again. But is that really, really bad? For example, that's using, in a sense, big data to try and attempt to provide you with options and choices. Is that something that competition law should be working to protect or to sort of prevent? And that's the sort of very difficult area that we have, right? Now, does that then take us into saying that we need ex ante laws to prevent the likes of Swiggy, to prevent the likes of Netflix, to prevent the likes of Google's, to stop them from providing us with suggestions? Is that what we want to try and do with ex ante? It shouldn't be, right? I'm raising questions now. I'm not giving you the answers yet on my own views on this. I'm just putting it out there first, just to sort of get us thinking about the different permutations. Now, Nisha knows that I can keep going on, so I'm just going to pause there with those questions, and I'll come back and provide the reverse thinking.
A lot of us come of the generation where we would, if it ain't broke, don't fix it, right? We've all seen the ex post facto regime. We've lived through the ex post facto regime. Anyone in India who reads newspapers looks at Google, for instance, right? My mother's not a competition lawyer, but she's heard about all of the Google cases because they're headlines front and center for months at a time, which basically shows that right now, when the Competition Commission of India does not have an ex-ante framework, they can still investigate a digital economy player, they can impose significant penalties, and they can change their behavior in terms of business practices when they pass directions against them. In light of that, what are the key considerations for ex-ante frameworks? What's happening in Europe? What's happening in Asia? Let's hear about Europe first from Phil, and Kala, who practices across Asia, will give us a quick flavor in terms of what's happening in those jurisdictions. And once we're done with that, Adiraj and Abhinav will have the industry view on, does India actually need an ex-ante law? Because like most of you here know, the government's constituted a committee, and the mandate of the committee is not to consider if India needs an ex-ante law, it is actually to draft the new digital competition law, right? Which is ex-ante. Phil?
Thanks, Nisha. So I'll just briefly outline what is new, partly already existing, partly also proposed in Europe. What is existing, but really only in terms of a regulation, a bit more than half a year old, is the DMA, so the Digital Markets Act in the European Union. And that already shows it's a separate act, it's a regulation, it's important, it's a regulation, it's not competition law, but there's of course a lot of parallelism, crossover, and in particular then anticipated conflict between this regulation and competition law. It's not the first time. We've had other regulations covering seemingly similar activities like geo-blocking as a prime example. We have consumer protection elements. It's very important. We'll get to that as well because we're talking about consumer business. And we have tools. So from competition law, you have merger control, which is in that sense also ex ante, transactional. You have otherwise, however, you intervene from a competition law perspective once you perceive or deem something to be anti-competitive. So it's behavioral. And there too, and that's the closest we get in looking at digital markets legislation, you have the concept of market dominance. In Europe, you even have by now crossover relative market power, so about dependencies. So you have lots of these concepts already there, and they're very similar, and but yet not the same. So what the Digital Market Act tries to achieve is it was used now several times, ex ante, certain aspects of it. It's regulation, and it introduces concepts that use different names but mean almost the same, like market dominance. We're talking about gatekeepers, so digital platforms. We are now defining the purpose of what the digital platforms do. So we have the concept or definition of core services, core platform services, and a list of types of services which basically cover the businesses that our colleagues do and all the companies that you know, and of course the big ones that were the very reason for this legislation. And again, you have quantitative elements, like in competition law, quantitative, qualitative. But here it's primarily you only have quantitative elements. And turnover, we know that too. Capitalization. Now, capitalization already is something we all know. I mean, we have market volatility. So now you look ex ante at a capitalization at point X, which will be a criteria for being defined, and that's another difference. So the authorities will assess, you are supposed to self-assess, and then to notify if you consider I am a gatekeeper, and that is what you then will be measured by. So metrics, and then the last one, and we already discussed before in our pre-discussion, it's about the number of users, active users, monthly active users, annual users, business users, B2C, B2B, and then to add on it, what is prospectively foreseeable your position and the number of users in 3 years. So do we see kind of a bottleneck effect on the horizon? You even then have to notify if you plan or intend to acquire players in your own sector. So that's another ex ante element. And from the outset, you don't, unlike in competition law, you don't have a defense. There is a possibility to rebut under exceptional circumstances that you're not a gatekeeper. There are no criteria as such. So that is one big open question. How will you get out of being qualified and then fall under the legislation? But unlike in competition law, where we have for dominant positions, you have legitimate business reasons. So you have tools that are there. This is in principle not is a per se. It's a definition. You fall under the legislation, and then there are a number of prohibitions and obligations. And that's pretty much it. And we'll get to what you can do afterwards later on. But so this is the real ex ante legislation in the EU, which we understand is being proposed and considered now in India as well, because competition law, your new Data Privacy Act, is all basically following what the EU has done, but under completely different circumstances at completely different times. And you've already alluded that majority of markets, we are copy-pasting something from somewhere else, which has been introduced for entirely different reasons, legitimate or not, but of course the ex-ante approach in Europe is also contested. Now we have the UK. They have also now, it's a bill, it's not yet in force, and that is closer to competition law. So it will also be tied into the existing competition law, the Competition Act of the UK, and the authorities, a separate unit, the Digital Markets Unit. And that is trying to find already a bit of a midway, a lot of similarities, but a less straight-jacketed approach. There's more of a regulatory dialogue intended, or at least for now in the bill, between the regulators and business. But still, so that is not yet in force, expected only next year. And we can get to some elements later on. And then we have Germany. Now, Germany, they have already amended they have taken a different approach. So they have amended their existing competition law, and many of you will know Germany, being Germany, they have very clear rules. They have a very strong authority that enforces, and in Europe, typically the German authority is a guiding authority, and often enough also, and that's what we foresee here, potentially conflicting with the European law, European legislation, and that may very well happen here, because they already said, well, we have rules, we put them into our existing Act on Competition, and also in terms of enforcement, to what extent it will be based on a dialogue, how strict it will it be ex ante or not, rather not. So they're really using the toolkit amended, which is probably a sensible approach. And since I'm from Switzerland, we do a lot of copy-paste of Europe. But even here, the thoughts of those, actually the former chairman of the Swiss Competition Commission was also, we more likely than not, we certainly shouldn't, we will not have new legislation. We rather also take the approach by applying our existing competition law, which we're going to amend only now, to European competition law, and use existing tools and amend them to suit digital markets. So you see what is going to happen, and which will more likely than not influence India, is the tight approach, that's the DMA, ex ante regulation, and once you're in, these are the rules, these are the obligations, these are the prohibitions, and then a lot of unclarity because it's not yet tested as such, and creating conflicts with competition law. You have a UK concept somewhere more subtle, and you have a German concept which looks at competition law, and conceptually the EU says, well, the DMA is meant to complement competition law. It's meant to apply in parallel, and at the same time it says, but the existing competition law should not hinder and prevent the implementation of the DMA. And now if you have member states that have competition laws in place like Germany and that take a different approach, you already from the outset have a potential conflict out there. So this is kind of currently the layout from a European perspective, which takes different approaches.
Thanks, Phil. Kala, given that India is so much closer to Asia in terms of development, what's happening across various Asian markets when it comes to ex ante? I know that Singapore, you've mentioned to us, has a very special model. Could you enlighten us on it?
Okay, so I'm always defiant. So sorry, Nisha. Can I just take a few points that he said? In terms of having ex ante laws, just again for everyone's knowledge, and you know this already, the key industries in which it sort of first grew was telco and media. And telco and media, I think the focus was slightly different. Telco, going back 25 years, it was a case of technology not being as advanced as it was, telecommunications not being as advanced as it was, thinking that things will move slowly, so let's see how to manage it, and hence ex ante laws were introduced. The bigger you are, the more spectrum space you have, you do ensure that you allow more players to come into the market so that there's competition. And the media, similar idea as well, but the media also had a consumer protection angle. The ex ante regime, I think in telecommunication, in media, worked to a certain extent. But when you look at it from a today perspective, although it continues, I question it. And from there to segue into Nisha's question, across Asia, there's no one country which has gone down the road definitively to say that we're going to have an ex ante approach in the same way as the DMA, the Digital Markets Act in the EC. And I think that's the right approach. Australia is looking at it and likely will go down the DMA route, will likely take an even stricter approach than the DMA route, and I don't think it quite works. Indonesia has introduced, not within its competition laws, but within other pieces of legislation, various sort of requirements for those in the platform industry, for example, to comply with. So that requires various disclosure requirements and so on, but not as a gatekeeper, because the gatekeeper role is a heavy-duty one. If I look at the other Asian countries, so far, nothing yet. In the case of Singapore, the Competition Act is very similar to the European one. It's not very different to India. But we have had market studies undertaken in looking at the digital world, looking at platforms and so on, and seeing whether there's really a competition harm. The last market study that was conducted was in 2020, and the conclusion reached was the marketplace is capable of handling itself. So we don't actually at this point in time need to introduce anything specific to address it. They didn't use the phrase ex ante. But having said that, we do have guidelines introduced, which has come up again for private consultation with businesses that deal with, for example, price coordination, where potentially algorithms are used and it allows for players in the digital markets to arrive at some degree of, I'm saying this, collusion in terms of pricing. So looking at that as just one example, what the CCCS in Singapore is trying to do is seek guidance to see how that can be prevented or controlled. So not an outright gatekeeper approach like the DMA in the EC. And I can understand why Singapore is doing it that way, because it's a consumer protection angle, to just make sure that we don't allow prices to using price as an example, to reach a level where there isn't any more competition as such between different players. So that's a Singapore angle. But looking at it overall, right, is ex ante really useful? What is the harm that ex ante is trying to correct? What is it trying to protect? And as I say that, I'm going to say something very rude. What gives one group of individuals the power to come out and say that we know how to protect better, and these are the rules by which you're going to play? I mean, today I might be a private lawyer, tomorrow I might be a regulator, right? I'm still that same head. Today I say ex ante doesn't work. What makes me think that tomorrow I think ex ante is going to work? So I'm just saying that, and I say it's rude because it is a suggestion that when regulators are trying to push ex ante, it is, I know better than you how to protect the market. And I find that somewhat worrying, actually, in this day and age. Why? Because with ex ante, and bear with me for another minute and a half or so, with ex ante, you are going to potentially prevent innovation. If I have to be a gatekeeper, if I have to keep following and playing by certain rules, if I have to keep opening my doors to let the allegedly small players come in as well, then it's going to stifle innovation. Why do I do it? Why would I want to do it? So that whole chilling effect that we talk about, we reference all the time, is a very real thing. And as I say that, doesn't our current expose approach deal with many of these issues? So in non-competition parlance, in legal parlance, it's a question of, do I want to have prescriptive rules or do I want to have principle-based rules? Ex ante is really prescriptive. And if it's prescriptive, you're setting out 1, 2, 3, 4. And if technology is evolving and you're looking and setting out that 5 elements as of today, what happens tomorrow when something changes? Do I keep changing the law? So practically, to me, it's not effective. As opposed to if I use expose. Expose it's always that rule of reason, right? We're all common law countries, or majority of us are common law countries. It's always that rule of reason. It's that reasonableness test. Although I always question, is there a reasonable man out there? But still taking the reasonableness test, it gives us some kind of basis. And it allows us to address issues even as they evolve. Now, Phil mentioned that one of the key concerns was it took regulators too long. Why are you taking so long? Is it, you need to interview people, you need to understand the market, you need to pull RFIs together to get responses and so on. But when it comes to us as private lawyers, we respond very quickly, right? So really, does it have to take so long? It can, in a sense, move a little quicker. And this is not India focused or Singapore focused or anything. It's just across the different countries. Because one of the key reasons put out there is because to rely on ex post, it means that the harm has already been caused. And the key reason for that is because it takes too long. Now, I come back to what is that harm that is being caused? Really, at the end of the day, what is that harm? Market power? Abusing market power? Could I have prevented that as I see what's going on and I jump in a little quicker? And one of my, this again is somewhat controversial. One of my favorite cases is CCI's decision in Google. Say what you want, I think it's a brilliant decision because it shows a regulator who was willing to, way after many other regulators who came in, decided to look at it, take a position on it, right, wrong, we question it separately, okay? But was willing to take a position on it and deal with the issue, was willing to consider potential remedies and deal with that remedy issues. So much so that other regulators look at CCI as well as a couple of other regulators across the world and say, hey, maybe we can do the same thing as well. So if you can do that ex post, why do we need an ex ante at this point in time? So there's a lot more sort of issues that we can outline. Maybe one last point, bargaining position. One of the arguments is the small guys can't grow, contrary to what the two business people have said. The small guys, they say that we are helping the small guys, but the regulators say that the small guys coming into the market can't grow because the incumbents stifle them out. They buy them out and so on. So your killer acquisitions and so on. But isn't there a better way to protect it than to say ex ante? And here I circle back to what Phil said about one of the requirements about DMA is you need to notify if you're going to acquire someone. But we already kind of have that in merger notifications. When we are acquiring another entity, we have to notify in any event. That merger control notification requirement in our existing competition laws is not entirely ex post. It is kind of ex ante because the regulator is going to look at it and say that, hey, the market has been operating this way historically, post this, how is it going to operate? And I think it's going to create this kind of problems. We want to put these remedies in. It's kind of ex ante already. So do we need more than that, even in the acquisition kind of scenarios? Pausing there.
Thank you, Kala. From Phil and Kala, we've heard and learned that with the DMA, it's a very strict do's and don'ts, right? Most of you would have seen that the Europeans decided that from the 4th of July, American independence, they will designate 5 of those 7 gatekeepers, all American companies, no European companies there, Samsung and ByteDance, as the 7 who will be regulated under the DMA. Europe also adopted a wait and watch approach where the DMA has been rolled in phases, right? It's taken them 5 years to designate somebody. And now the obligations for these 7 will kick in over the next 6 months and then following that over a year, right? So they have taken a sensible approach in terms of timelines of introduction, not necessarily in terms of the model which is being introduced, right? But this DMA has become the gold standard suddenly. It is completely untested, right? Because even Europe has not passed a single decision under the DMA, right? In light of that and the fact that rest of Asia, like Kala has mentioned so very clearly, is doing absolutely nothing in terms of introducing an ex ante, right? The need of the hour for industry here, Adiraj, and this one specifically for you, without commenting on the facts of your case, because you've been under investigation at the CCI. The CCI passed an order as a digital player. They also passed under the ex post regime, right, interim relief measures, which shows that in a dynamic market, the CCI obviously right now has the tools of the trade to intervene. What is the need of the hour, given where India is today in terms of economic development, in terms of investment, and in terms of whether you believe Indian industry has already attained sufficient scale?
Thanks, Nisha. Let me answer this in 2 parts. The first is there any power that we feel the CCI was really lacking today? I think the answer is a resounding no. As you already kindly mentioned, the CCI has already shown that they can pass interim directions We've already seen enough and more case law where CCI has used concepts such as gatekeeper, they've used trust-based approaches, and they have imported concepts which they feel were appropriate from all jurisdictions and set to task companies in India. The Google decision, as Kala kindly mentioned, is an excellent example of where CCI was not limited by the legislation which gave birth to it. Now, let me just quickly also address what we are really talking about when we talk about digital markets in India. And for a second, let's forget companies like Google, Facebook, and other giants, which are actually the ones who make a buck in any jurisdiction they go to. I come from a middle-class Indian family, all right? If you go to my home and you ask my mother, should I order pizza from Swiggy? She'll be like, I can make a better pizza at home, all right? If you ask her that, should I order you some utensils from Amazon? She'll say, no, there's Jolly store over there. I know that guy really well. Let's go there and I can see everything there is. Leave that. If I tell her that you want new running shoes, maybe I can take you to Adidas or Nike. Her definition of online shopping, and I'm sure this is not new to any of you, is to go to the shop, see whatever shoe she likes the most, wear it, try it out, then maybe go online and order the exact same shoe in the exact same size from there. All right. Now, the point I'm trying to make is that 15 years ago, internet penetration in the EU was at about 70 to 80%. India today has not reached that stage. And even when you talk about internet penetration, the kind of internet penetration is very different. It's very different to have an Amazon which you use after you've gone to a physical store versus in EU where there are judgments which say the customer loyalty was a very big thing and the manner in which internet was used was very different. So just keep that in mind and let me take you to another concept. Who in India, in terms of digital markets and in terms of Indian companies that the legislation is seeking to legislate, is really making money or causing any competitive harm? Is Swiggy or Zomato or Nykaa, a couple of these companies are publicly listed already. Are they really rolling in cash? The answer is no. Most of them are struggling to turn a profit even today. Are any of the online travel agencies really rolling in money? No, they're barely just recovering from COVID and finally starting to report positive profit quarters. Is there any major competitive harm that has been identified till now? No. Is the market share of online companies so large so as to cause the government to take proactive action? The answer is no. Just like we all know the moment you step to a tier 2 city, Swiggy, Zomato is not really a factor. It might be a factor in South Delhi or South Bombay where young people like to order food every day, but that is a really, really small percentage of this country. Similarly, when we talk about travel, 70 to 75% of bookings still happen offline. It might be unthinkable to us sitting over here in a metro that, oh my God, 70% of bookings are happening online. But that is the truth of this country. And if you look at it in this context, you will realize the fact that online travel companies might make a little bit of money off Delhi, Bangalore, and Bombay. But apart from that, they're not making money anywhere else. They're barely scratching the surface, and they are in the process of becoming competitive. Maybe 10 years down the line, they will reach the scale of Google or Facebook when they truly penetrate the country and they truly change consumer behavior and truly consumers and businesses feel that there is some benefit that these online platforms give us. But until that stage comes, until you can identify a harm that you have sought to remedy, until you feel that the current laws are insufficient to tackle any harm that is happening, just adopting regulation because similar regulation exists elsewhere abroad is not conducive and in fact will really detrimentally harm the growth of Indian companies who are just starting to hit their stride, who are just starting to take advantage of UPI and digital India and are just starting to expand their wings and looking at other jurisdictions and wondering how can we take Indian digital companies to the world? How can we establish other markets? I do not think this is the correct time or place to begin contemplating any additional legislation, much less ex-ante legislation.
Abhinav?
Sure, thanks. And I'll just pick up from where Adhiraj left off. So, it's important for us, I think, to kind of draw a distinction between the digital economy of India and the digital economy of more sort of developed economies, right? In the Indian context, the startup ecosystem has just started flourishing in the past few years, and even then. The market share that they represent is fairly small as compared to the likes of big tech companies, right? That represent a majority of the market that they operate in. And in that context, it's extremely important to distinguish between companies that are providing core digital infrastructure services on the basis of which the rest of the digital economy is operating, and a digitally enabled services, right? Something like a food delivery app, for example. And in this context, speaking of ex-ante regulations, right? Now, ex-ante regulations no doubt will reduce the number of instances where reduce the number of instances of no intervention when intervention was required to correct market dynamics from a competition law perspective. However, the risk obviously is that there it is likely that there would be over intervention and over regulation in sectors where there is actually no requirement of intervention, right, at this stage. And this is especially significant in the context of the Indian digital economy, where many sectors do not necessarily require intervention at this stage. One of the possible solutions here is obviously maybe to conduct a specific market study on a sector-specific basis, because it is I don't think it's correct to paint all players in the digital economy with the same brush, and we'll sort of need to identify sectors which have potential for causing harm.
Thank you. We have enough time for just 2 last questions on the panel, and then we'll open up the floor to Q&A. Right? The DMA and the DMCC both have one particular feature in addition to everything bad we've identified, which as a lawyer spikes my blood pressure. Right? It basically has the judicial review standard. What does that mean? The competition regulators in the EU, and if the DMCC does become law, because it's currently a bill in the UK, it'll be the CMA, right? Once they take a decision in a dynamic, evolving market, if they get that decision wrong, on appeal as an affected party, you can only appeal on the judicial review standard, which means if there's been a violation of due process, if there's been actual predetermination or bias, not if an honest mistake has been made, they didn't understand the market, or they got the market wrong, right? So you cannot do that at all there, right? In light of that, this is a question for Kala, right? Kala, how do you see this entire framework of ex-ante across the board developing? Right? If regulators are going to intervene in markets which are evolving so fast that they're claiming they need to do so, because otherwise, if they don't intervene in time, markets will tip. But if they get it wrong, then they have the ability to completely decimate that market, right? Their error will kill that market and chill innovation and investment completely. How do you think a balance can be struck, if at all?
Well, if they went down that road, I don't think a balance can be struck. That's the reality. Because if you go with a strict approach and the only way to resolve it is judicial review, and I'm sure many of you have taken cases on judicial review, it is very hard to say that the process was wrong or that a piece of law was fundamentally inaccurate, because at the end of the day, it's discretion of the regulator. So no, it's just not going to work. And if India hasn't introduced, I mean, I know there's been a lot of talk. I know there's the papers out. I hope it's not going to be passed as a matter of fact, as is, because the risks are just too much. And even as I say that, right, one additional element to take note of is the point just slipped out of my head. In relation to the better way to sort of deal with solutions is not to go with an ex ante approach, but really looking at existing rules. One of the key powers that regulators already have is the ability to require remedies, whether you call it commitments, whether you call it remedies. And rather than prescribe upfront what needs to be done, if I think you've been doing something wrong, I will prescribe some remedies in between. And I require you to try and change your behavior because of that. I didn't mention this just now, but Indonesia has now introduced that. So even the largest of players, you can introduce a scheme to show that you have genuinely changed your behavior, and that change of behavior will require a give back to the country as well. That is a much better approach to go with rather than strict. We make a decision. Everyone knows that market definition is very difficult. And it's always difficult to sort of settle on what it's going to be. And given that knowing your only recourse is judicial review, no.
Thanks, Kala. Phil, the famous Swiss precision, 2 minutes.
I don't know whether I meant two for all, because it's just briefly front end, back end, just going briefly back, merger control. The point with merger control, again, the argument of the regulator is, and that's to some extent true, but even that could be remedied and has already been to some extent in merger control, with the quantitative criteria that we traditionally had and to some extent still have. Of course, you do not catch many transactions, in particular in novel markets. And so that is, of course, where the regulator now comes with the other extreme. We catch, or we do have an ex ante review for anything that happens in this particular sector. And there, then at least you would say, but then you have to introduce a de minimis, somewhat a de minimis threshold. So that is to balance that many transactions did not get caught because the thresholds were simply too high. Now, the back-end judicial review, the DMA and the UK proposal, DMCC, actually there, the DMCC has a more limited judicial review in its proposal, whereas the DMA has pretty much a full review, not only on law, but also on the substance, on the merits of the decision. Of course, to some extent, that's where the delays also come from, the whole processes that take years, because you have a first instance decision. You definitely have an interest to have judicial remedies, because an authority is an authority, and often it does not have apply the same principles as a court of law. But then the question is, and typically you have two instances. The first instance often has full review, and then the last instance potentially only limited review. So here it will pan out which will be the better solution. In principle, you want to have some sort of review, but of course it's another delay factor as well.
Adiraj, the last word from Chandrayaan 3 to creating domestic champions to now potentially copycat behavior and adopting someone else's law. What do you have to say about that?
Let me just quickly address the point of chilling innovation that you mentioned, which I think is really interesting. And mind you, this is completely personal. I'm not speaking on behalf of my company here. But when I was younger, I was a boxer. And I don't ever think that I went into practice wanting to be a reasonable or a just boxer. I went in there practicing every day, wanting to kill everyone. When Google was started, they did not think that they wanted to create a just company which treats everyone fairly. They wanted to take over the world. That is how you change the world. If you want innovation to flourish, you cannot begin by coming to my boxing practice, looking at me practicing and saying that I think you should only fight with your left hand because you seem to be really good. Or you've won 3 fights in a row. Now your right hand should be tied behind your back so that it is fair for everyone. That's not the way you encourage innovation. I'm not at all saying belittling competition law. There is definitely something to be said about making sure there's no adverse effect on the market. But you really have to be mindful about where the spirit of innovation comes from, where the spirit of business comes from. People come out there and they think of crazy ways to make new money, and that is what drives the economy and the world forward. And if you start sending a message saying that if your idea looks too good, or if you're looking like you're becoming too successful, whether or not you're doing anything wrong, I might have to start putting fetters on you or judging you. I just don't think that's principally a way to go. But that's my personal opinion only.